Phil Silberman here from the Silberman Law Firm today, and we're going to go over the basics of a Texas will and some of the major clauses. The will I have in front of me here on the screen today is the will for a husband in a typical nuclear family where both husband and wife have minor children. This will allow us to go through all the basic stuff that would be included with a single person, but also touch on a trust for minor children as well as designating or appointing a guardian in the event that both spouses pass. So let's go ahead and dig in and get started. We have the basic recitation of a will that includes testamentary intent. That's a major requirement of every will, that the testator, that's the person making the will, have testamentary intent. You see that here where the testator says that he's intending to dispose of his property. The other thing that almost all good wills do is they revoke former wills and codicils. So the term last will and testament quite literally means the last will of that person that he made. And for purposes of clarity, most good wills revoke all former wills and codicils to avoid all doubt that this is in fact the last will. Moving along, we have some basic identity information of the family that lists the spouse and any children. And then we come to the next section, which is payment of expenses. It just directs that the executor should pay all expenses associated with the estate out of the estate. And then you get into the heart of the will, which is the disposition of the estate. Again, this is will of husband, nuclear family. So you typically see his assets going to his wife. In this case, the sample is Jill Smith. So when husband dies, he leaves everything to wife. But if wife predeceases husband, then he's going to give everything to his children, in this case, one child. And then this B, this kind of section here, B, within the disposition of the estate is actually very, very important. It's what's known, even though it's not labeled as such, it's what's known as the residuary clause. The residuary clauses in Texas wills are the opposite of what you think they mean. It actually is you get all the good stuff. So if anything's not specifically enumerated in the will, specific bequests or gifts aren't enumerated, then this residuary clause kind of catches everything and disposes it accordingly. So you've got a very important residuary clause here. You've got a definition of survival. This comes into play in the event maybe you have an untimely demise during a car accident where both husband and wife die simultaneously. So this clause addresses that. Then we get into the contingent trust section. This is very important because let's say maybe wife predeceases husband, and then husband then leaves his assets to his children. But if the children are still minors, or let's say they're 25 years old and really they're not mentally mature enough to manage property. In this case, we pick 30. That's kind of a typical age where in today's day we think that adults should be able to properly manage a sum of money that they inherited at the age of 30. So in the event the wife predeceases, children get the assets in trust. So this section will appoint a trustee, a financial trustee, to take care of the assets for the benefit of the children until they reach a certain age, typically 30, or at least in this will, it was 30 years old. It appoints a trustee, usually someone that's good with money, because when you pass and you want to let your children have a trustee that is financially responsible. And then it specifically lists the powers of the trustee and some of the directions. Pretty typical stuff. And then we have the appointment of the executor. So you've got, typically it's the wife. In this case, this is the husband's will, so it's typically the wife that's appointed as the independent executor of the estate. Independent executor to serve without bond. That's very, very important language in a good will in Texas, because it allows the executor to serve without court supervision. In Texas, dependent administrations are with court supervision, and those are very, very expensive. And they typically require the executor to serve with a bond, which is at an added expense, and it also requires some unnecessary steps of having to get a bond and go through a credit check and all that. You don't want that for your executor. This is very simple. My wife serves independently without court supervision and no need to furnish a bond. Then you've got the powers of the executor listed here. Pretty basic stuff. Dispose of the estate, pay expenses, settle claims, things like that. And now again, this is a will that envisions where the husband had minor children. So this allows the husband to appoint a guardian in the event both the spouse again predeceases. In that case, you've got minor children, and you're going to appoint a guardian. In this one, it happened to be the same person that was appointed trustee, but it doesn't have to be. The concept of a personal guardian for a child is different than a financial guardian. It could be the same person, or it could be a different person. So, maybe you've got someone that's really good with kids and a very loving person, but they're terrible with money. Well, that person could be the guardian of the person, and then say you've got someone that's good with money. That person could be the trustee of the children's finances. So that you see that sometimes. Then you have the spendthrift provision. This is a pretty typical provision that's in all good Texas wills, where it just says that the creditors don't get at the estate if the beneficiaries have a bunch of creditors coming after them. This paragraph addresses that. And then we have an interim clause, which is also known as a no contest clause. Basically, if anybody contests the will, it usually says that they won't inherit. If I always like to point out, if someone has a really good will contest case, don't let a no contest clause get in the way of that. There's sort of a high burden there, where if someone brings a will contest case in good faith, and it's not meant to thwart the testator's intentions, which is the standard, then the no contest clause really doesn't come into play. And then we keep moving right along here. You've got basic definitions and interpretation section. Not a lot interesting to talk about there. And then at the very end, we get to the technical things that make a Texas will valid. If a will in Texas is not a holographic will, or not a written in their own hand, then obviously this is a print will. You need to have it signed by two witnesses. So for a will to be valid, it's got to be signed by the testator. In this case, the husband, John Smith. It has to have testamentary intent, which we've already gone over that. The will clearly laid out that the husband had testamentary intent and was intending to dispose of his estate. And it has to be signed by two witnesses. So your witnesses go here. In this case, they have to, well, in all cases, they have to be over the age of 14. And you've got a basic recitation to make the will self-proven, which is very, very important for avoiding some unnecessary expense. So your testator signs here, your two witnesses sign there, and then you have it acknowledged in front of a notary. And that brings us to the end, and that goes over the basics. We've just finished the basics of any good Texas will. As always, please remember to consult with a good estate planning attorney or probate attorney when considering drafting a will or having a will drafted. And appreciate you watching. Uh,